United States against Mr. Benn and others. Ms. Barrett? And do you represent Mr. Benn?
I represent
Okay.
Mr. Benn, yes, Your Honor. I'm going to run through this pretty quickly, but, welcome to stop at any minute that you want to. The crux of what I wanted to talk about is the sufficiency issue, sufficiency of the evidence to convict. We're not talking about credibility. Credibility. That was a jury question. We understand the jury found the witnesses credible. However, our position is that the evidence should not have been given to the jury because it was unreliable in the sense that it was not given a proper foundation, not backed up and by some kind of standard of review that the court could make a decision that it was reliable evidence.
You're talking about the cooperating
witnesses is what I'm going to talk about.
Immunized witnesses?
Yes, sir.
That they weren't reliable?
Yes, sir. We have.
Aren't there, but in their evidence enough, if it's believable?
No, sir.
They have to be corroborated.
I think there's
Is that what the instruction was?
That's part of it, although there are a couple of cases only. There's no case directly on point regarding how you qualify or assess the reliability of informant's testimony. The cases that I have found deal mainly with detainees and prisoner rights, primarily coming out of the Guantanamo Bay cases. And those cases do say that an informant's testimony against another detainee is not sufficient, clearly say not sufficient, to be held reliable for detaining another person. And in my opinion, that means that we should have a higher standard.
Is that military law?
Yes, sir.
That's military law.
Yes, sir.
That's not the law enforcement circuit.
I know, but I think that you can make some analogy there between those cases. And what I'm looking for in cases and what I'm looking for in the court is some kind of standard whereby you and the trial court know how to assess the reliability of the informant's testimony before it's offered.
Standard was, the jury everybody has to view testimony of an informant or a cooperating witness with caution and weigh it with great care and all that. But if the jury determined it's credible.
However, the issue that we have with that is that is too broad, not a specific enough standard, and that there are some points that have been brought up in various cases, not put together in one case that we would like to see the court address in terms of giving some kind of direction from here forward.
And what kind of direction are you seeking?
I'm seeking an opinion that lays out a standard for assessing the...
What standard?
Okay, the standards, the points that we would like to see are that informant's testimony has first of all got to be corroborated by other reliable testimony. So it's kind of, it's hard to, you're jumping from this isn't reliable, but is this reliable to make that reliable?
What if you have two informants? Does that do it?
Well,
the second informant corroborates the first.
It could be. Quantity doesn't make up for quality, though. So, what we'd like to see is that is a standard laid out that says you've got to have corroboration from other testimony or evidence, not necessarily informant testimony, but other evidence. You've got to have specificity in the testimony that comes from the informants, and that was a problem in this case that they gave different statements. The informants.
It sounds like you're arguing an instructional issue rather than simply a sufficiency of evidence. You're disappointed that Judge Schroeder didn't instruct.
Well, it all
properly.
adds up, and you've got to look at the totality of the evidence to determine whether or not it was sufficient. And one of my other panel attorneys is going to talk about sufficiency in a little more detail, but we had to split this up into quite narrow little topics for the little bit.
But you're bringing it up here in the context of sufficiency.
That's exactly right.
But it sounds to me like you're really arguing about an instruction, that you think it should have been instructed differently, that the jury should have been given a more favorable standard to your client.
Well, that it could be handled that way, although what we really wanted was for the testimony to be excluded. because we don't feel
To
like
be
it was-
excluded. You thought
because it wasn't reliable.
the informant's testimony should have been excluded. Okay.
Exactly. Along with the expert testimony too, and someone
Well,
else.
then
is
it's an
gonna talk about that.
admissibility question. Then you're raising an admissibility question rather than a sufficiency question.
No, we're talking strictly about sufficiency. Strictly about sufficiency. And if I could just run quickly through the points on the standard that we'd like to see is that there have been a couple of cases that talk about informants' testimony and suggest that the government should have some way of showing that that informant has a proven track record, that they have been used before as an informant, that they're that they have told the same story, the same time, the same way over and over again, that their testimony can be relied upon as being truthful and honest. That wasn't done in this case. The absence of any other undermining testimony is another point that could be raised as far as setting a standard for assessing reliability.
But you don't raise the jinx issue, do you?
Excuse me?
You don't raise the jinx issue here. You said whether it was reliable. Prior testimony, you said to make sure it was consistent. There's no jinx issue here, is there? You're not raising the jinx issue in terms of they said something totally different that therefore the government should have been on notice to tell you that you're just assuming.
Well, in this particular case, the statements that some of the informants, and I just don't have time to get into detail in the record of which ones and what they said exactly, but the statements that they made to the investigators were not exactly the same, and they actually admitted that on the stand when they gave testimony in court, that they may have misspoken or they'd forgotten something, it wasn't quite this, it wasn't quite that.
And you used that artfully in cross-examination, didn't you? That was used artfully in cross-examination to
Yes.
put a
for-
chink
for
in their
certain.
armor, correct?
Yes, yes. I need to say, my client has requested, and I want to throw this in here at some point because he's waiting to hear this come out in the transcript, that he also feels like his case should have been severed from the other defendants because they're arguing making contrary arguments to his. He thinks that the Alien case applies to him in terms of the drug quantity determination. That the jury found by special verdict a drug quantity for him, and then the judge found as a sentencing enhancement factor a higher drug quantity. He takes issue with that. I'm just throwing that out there. I don't see those issues myself, but if you do, I'd be happy to have that happen. So just want to be sure that he knows that I did mention those.
Thank you, Ms. Barrett.
Certainly.
Let's see. Mr. McClellan?
May it please the court, my name is Robert McClellan. I'm an attorney from Greensboro. I represent Mr. Sean Jeffries. And the issue that I would like to speak to primarily is one of the amounts of drugs and how this was allocated to particular defendants. One particular anomaly in this particular case, as the court might recall, is that there was a jury asked to look at count one, which was one dealing with cocaine-based crack, one other count that was a separate object that dealt with cocaine hydrochloride. And the jury came back with a limiting special verdict as to the cocaine hydrochloride. While the jury came back and said there was 280 grams of crack, they also came back as the cocaine hydrochloride and said that, yes, we believe there's more than 500 grams, but less than 5 kilos of cocaine hydrochloride. This is special as to my particular client. But the issues that several of the defendants have raised in this is how the judge allocated this crack. Also, what they did in this case was a conversion, because the judge, as you might recall, in sentencing, took that same amount of cocaine hydrochloride and multiplied it under a conversion, and such that they ended up with, in my particular client, as well as some of the others, 18 kilos of cocaine is what was the final allocation based on the issue of it being crack cocaine. The circumstances that we have here are ones that we're contending, of course, that the jury had made a decision about what was the appropriate allocation. And that was ignored by the trial court in terms of arriving at a larger amount. Also, too, as the court might recall, in this case, there were some trips that were made. They were allocated to my particular client. One was a trip to Atlanta that was occurred in 2008, where a number of people went to Atlanta, and supposedly 8 kilos were returned. Well, there was also a trip to Texas in which they took money amounts, not cocaine, and converted that into cocaine, and then converted that into crack cocaine. So it's a number of bootstrapping conversions that are occurring here. We contended, and was contended at trial, that Mr. Jeffries had nothing to do with the trip to Atlanta in terms of the cocaine that was found on that particular trip. He was riding with other individuals. The jury had to agree with that because there were 8 kilos of cocaine on that particular trip, and the jury found that there was not more than 5 involved with cocaine hydrochloride. So the jury had to have agreed that that particular trip was not attributable to my particular client. That's one concern we have about the trial court.
Who all was on that trip?
On that particular trip was Mr. Benn, Mr. Jeffries. There was another couple of individuals that went that were unindicted co-conspirators, supposedly. Mr. Benn was the one who went down there for the trip. He was the one who drove, as I recall. And you might recall that somebody jumped out of the car with 8 kilos and ran some location.
The police
Yeah.
were chasing them.
That's right.
They jumped out of the car and hit it all.
And another
Went
person
back and got it.
and my client went back to a hotel room with another person. And so he was not directly involved in the cocaine itself. He was not trying to hide it. He was not a person that was directly involved in going down there for it. And the jury obviously found that because they said it was less
Did he do
than
any
5.
driving?
Excuse me?
Did he drive?
No. As a
No
matter of fact,
evidence that he drove either?
I believe he was just a passenger, and the only time that he had anything to do with driving was they had taken Mr. Benn down for questioning, and my client drove the other individual to a hotel room where they stayed.
But doesn't the Young case in the Fourth Circuit permit the district court to find a greater drug quantity at sentencing than the jury found?
Well, the Alton case has some issues with that because we're going back now to where the Supreme Court is saying that Alton said we're going to give more credence to the jury making decisions about what should occur in this case, what thresholds are met, what are going to be elements of the case. And certainly here the judge charged the jury and told them here's the levels of which you should decide. You should decide what the amount should be. And the jury was given that option and they found the lower amount. And so with that in mind, the judge is saying to the jury, yes, I'm going to listen to what you have, but I'm going to tell you also that I might disregard that. And so the jury doesn't know that. They're knowing or believing they're establishing what the drug quantities would be, and that was later determined not to be of effect to the court. So we contend that the drug quantities should be looked at, and certainly in terms of a lien now being a factor, the fact that the jury found that there was less than not more than 5 kilos, and yet some of these calculations directly involve more than that. Any other questions from the court? I believe my time has expired.
Thank you very much, sir.
Thank you, Your Honor.
Mr. Fisher?
May it please the court. I'm Clark Fisher of the Ashe County, North Carolina Bar, appearing on behalf of Robert Poole. And what I'd like to do this morning is briefly address the sufficiency of the evidence argument, specifically as it relates to Mr. Poole. Now,
That's the only issue you raised,
the
right?
only issue, yes, sir. You know,
There was not enough evidence to convict him.
that is absolutely correct, Your Honor. And I would certainly, echo the argument made by Ms. Barrett as to the general reliability of Mr. Williams. But even accepting that Williams was credible for purposes of this argument, giving the government the benefit of all appropriate, reasonable inferences, we contend that the evidence showed only that Poole was so far down the line in this Bundy Boy drug operation that while he perhaps could properly have been convicted of substantive offenses such as possession with intent, they found him with 14 grams one time, possession of cocaine, but he was not a member of this Bundy Boys conspirator. If you look at the evidence, most of which had nothing to do with Robert Poole in this case, but the evidence that did apply to him, you have a picture of a longtime drug addict who clearly never made a cent off of this. What he did, he was paid for in crumbs. Repeated government witnesses testified to that. And his activities were as a taster, which I guess is consistent with getting paid in crumbs to make sure that the crack was
Being
in
a
fact
taster, you say, is so much a minor participant that he's no participant at all.
in the conspiracy. Yes, sir. That would
He's
be
not
our
in the
position.
conspiracy.
Not
He's
in the
not a
conspiracy.
conspirator, even though he was a taster.
Yeah, you
And
would-
he was, of course, I'm sure you were getting to this, he was more than a taster, though. He tasted it, he packed it, he distributed it, he, wasn't he the one that ran with it
that's-
out of the back of the van?
that is correct.
Was that on the trip back from
So-
Atlanta?
Well, I think this one was from Gwinnett County, Georgia, if I'm remembering the facts right. There was evidence of a variety of trips to different locations in Georgia, but I think that's an interesting point because if you read Mr. Poole's pre-sentence report, I think it's paragraph 25, we learned some new vocabulary. Apparently he was a mope. And a mope is somebody whose job is to take drugs in the event that the people who we contend, if you accept the government's evidence, are in fact the conspirators, take the drugs and run, so it's the mope that might get caught, not the people
So
who are
the
actually
mope,
running
then,
the operation.
by that description, is a pretty integral part of maintaining the conspiracy and the operation. Everybody plays a role, and he sounds as though he played several roles, although he may not have been the one making all the money.
Well, certainly everybody plays a role, Jim Snacker. Of course, everybody at General Motors who builds one of those cars plays a role, but they are not all involved in any organizational sense. Of course, you look at the government's evidence
If
in this
making
case.
cars was illegal, they might be.
Well, not yet.
No, you made that analogy, but
Well-
just because, making cars is not illegal, but if you were on the assembly line every day, welding the parts, painting them, that would be consistent with a conspiracy to manufacture automobiles, wouldn't it?
Your Honor, I would contend that would be an overbroad interpretation of criminal conspiracy. Looking at the facts of this case.
So your position basically is application of conspiracy law to this set of facts as to your client.
Yes, sir.
It just doesn't reach your client.
Yes, sir.
That's what you're saying.
Yes, sir. We
It's
certainly.
too far
down.
the line.
Yes, sir.
Even though he may be guilty of a substantive offense, you say.
Yes, sir. I absolutely. I think the government clearly proved, at least as to that 14 grams he was caught with.
But the problem is,
Possession with intent.
I appreciate your argument. I think you're making a good argument. But the problem is the small role that he has, albeit small and far down, is integral to the conspiracy. You're tasting more than the amount you're going to use to test it for the enterprise. You're running with more than you're going to use to protect the enterprise. That's the problem. It doesn't matter how far down you are. If you know the enterprise and you're doing something, if he was running with just small amounts, that's okay. I'm going to take the little bit that's mine and I'm getting out of here. Or I'm going to taste what you gave me, make sure it's good, and I'm gone. But you're tasting to verify the quality of the big thing for the big thing. You see what I'm saying? I don't see how you disconnect the small thing from the big thing when everything you're admitting to relates to making the big thing work. Because if you get bad drugs, they can't sell bad drugs. If you get caught with your big supply, you go to jail. That's why you run away with it. How did you get away from that?
Well, Your Honor, I think you have to look at the specific conspiracy the government alleged. It's the Bundy Boys conspiracy. No question about that. A historical conspiracy went on for years, involved multiple drug houses in the area. And the government's evidence was that, again, if you accept that with all due deference to co-counsel, Benn's the president. This is what Williams described. Williams was the vice president. Then you had other officers, clearly all involved in organizational activities. And then way down here, you have somebody like our poor, pathetic drug addict, Mr. Poole, who we contend his role was qualitatively different, and it wasn't even that slight connection that Preston applies. And here, unusually, we have not one, but two government witnesses, Tashi Mumford and Helen Greer, both of whom said Robert Poole was not a Bundy boy. He was a smoker, he was a taster, but he wasn't a Bundy boy. And on the evidence you have here, if he's not a Bundy boy, I will contend he's not a co-conspirator. Guilty of substantive offenses? Absolutely, but the government didn't charge those. And I see I'm...
Did he get the lightest sentence?
He did. He got 114 months, which was substantially lower than the other defendants. He did.
So your proposition that he was a minor participant
Well, I think
was
the
taken
government
into
concedes
account.
that he was...
Well, you say he's not a participant at all.
In the
but
conspiracy.
He was such a minor participant that he wasn't even guilty of conspiracy. But he did get the lighter sentence.
Yes, sir. And the jury, of course, found him, in terms of the drug quantity, substantially lower than the other people. Our position is that's a start. We ask the court to take it one step.
Oh, you all were the trial lawyers at the case?
I was not, Your Honor.
You were not.
And unless there's any other questions, I will look forward to my remaining 60 seconds. And let me just say, anytime you want to hold court in Charleston, please put me on the list.
Well, there's another Charleston in the circuit, you know.
Well, I'll go anywhere.
All right.
Thank you.
Mr. Johnson?
Good morning, Your Honors. My name is Thomas H. Johnson of the Guilford County Bar, Greensboro, North Carolina. I am counsel for Mr. Kevin Hayes. The court inquired as to Mr. Fisher whether there was trial counsel. I was trial counsel for Mr. Kevin Hayes in the course of this trial. The issue that I would bring to the court is one with regards to the admissibility or admission of an expert witness, Corporal Marsh, corporal with the Greensboro Police Department. He wasn't a captain, he wasn't a chief, he wasn't a major, he was a corporal. On February the 7th, Defendant Benn filed a request for discovery of the expert witnesses. There was no response. On the 16th, a notice was given of an expert witness, Corporal Marsh.
And trial had already commenced by the time that notice was given, is that correct?
Yes, Judge Thacker, trial commenced on the 13th. Jury voir dire had begun. The jury had been impaneled. Witnesses had been examined, direct testimony, and cross-examined by the defense.
Other witnesses?
Yes, Your Honor. That discovery had been given. There was no mention of a Corporal Marsh as a expert witness in the volumes of discovery, which was hard copy and also digital.
What was his expertise characterized as?
Well, Your Honor, I contended that he had no expertise
I know
whatsoever.
you did, but the government contended that what, he was expert in street talk or
That-
telephone talk or code for drugs or what was it?
The government's contention was to put on evidence on the use of guns in furtherance of drug trafficking and distribution of crimes in their response to my motion in limine that I filed.
Connection of drugs and guns. Would that be the?
Well, Judge, the evidence, if you're in the trial, the evidence speaks for itself. There's a charge of the 924C, use of firearm during and in relation to a drug trafficking offense. That is not necessarily what Corporal Marsh's testimony pertained to. What he wanted to say was that it was in protection of drugs or that they were used in violence, that violence begets violence, which kind of heightens the anxiety of the courtroom, the anxiety of the trial in and of itself, a sort of misplaced context of fear, which is a problem.
You wouldn't have a problem if he got on the stand and said they were involved in drug trafficking, and that normally follows that you have guns. Is that been a problem?
Well, Judge, I have to defend my client with the evidence that's presented. There was evidence, and there was evidence of drugs. There was evidence of guns. However, the trial starts on the 13th. I've been given the discovery 2 months earlier. Been preparing for trial. On the third day of trial, on the 16th, you're going to tell me you're going to bring in a new witness, and you're going to tell me he's going to be called an expert, and he's going to get that favorable rating.
Didn't you ask? Wasn't there a request for an expert disclosure a week before trial?
That's correct, Your Honor.
Why did they come back and ask for another go at it when they didn't? When there was no notice of an expert, the 2-month material they got?
Judge, there was no response by the government to the request for the disclosure of experts that was filed on the 10th.
The judge said something like, this is the way they normally do it.
Well, Judge,
I think, that's my recollection of it. The way they normally do it was this way.
what we normally do is an open file.
You do down there?
Yes, Your
The
Honor.
U.S. Attorney gives you an open file.
U.S. Attorney gives us an open file. It's either in hard copy or it's in a digital
Did you have an
format.
open file here? There was nothing in the file about?
There's nothing in the file about Corporal Marsh
Nothing
being,
in the file,
about being an expert
as
witness
being an expert witness.
or his training. And I requested what training he had, what expertise, what scientific methods he was prepared to testify under the Daubert
He
standard.
didn't give you an expert report.
No
You
expert
never did get a
report.
report.
He didn't have a report.
But right, you didn't make a report.
He didn't make a report.
But the timing,
Surprise,
Is it- I
surprise,
understand,
surprise.
but that issue is something we review for abuse of discretion, right?
Well, it's an abuse of discretion, Judge.
We have to review it. We have to give the judge some.
You got to give the judge some
Leeway.
leeway,
On that.
whether.
But
it-
I'm more concerned
the-
with what the expertise is. I mean, what guns and drugs.
Well, Judge,
Sounds
any
more like
corporal-
common sense, doesn't it?
What had he been trained for? Was he trained to testify as an expert? No. Was he trained to testify in the
As an
course of
expert in guns and drugs,
and
it has to be in
drug
this field or whatever it was.
Well, his field is the law enforcement for the city of Greensboro.
Was he in uniform?
I don't recall him being in uniform. He was in a jacket, tie.
When you filed your response to motion,
The motion
when they
to eliminate?
filed the response to your motion, what was it the government said this expert was gonna,
Government's purpose
Opine
was
on.
to put on evidence on the use of guns in furtherance of drug trafficking and distribution crimes in their response to the motion to eliminate, to my motion to eliminate, Judge. That in a nutshell, that's to take the line from their response. We contend that you have prepared and joined for trial. The lines are set. The evidence is what the evidence is. It's very surprising ambush to be in trial 3 days and find that you're going to get an expert and not have an opportunity. We're already in trial. We cannot get our own expert. That is one way to try to deal with some experts, is that you get your own. We're in trial. I am in trial with Mr. Hayes from 9:30 to 5. Well, sometimes we're going to 6 o'clock that day.
What would you have an expert say? That guns and drugs don't go together?
Well, Judge, in the typical context, I get the whether it's the government's witness or in a civil case, the other side's vitae of the expert, the report, and then I check and see if there's another expert in that field that can give a report favorable to my client or my side on that particular expertise.
Right, we can appreciate you don't have the same Rule 26 type of devices you have on the civil side, but my question, I think, would lead Judge King's permission, just so if I can recast this question as I understand it, what is the core of what Marsh said? The core, as the French would say, the piece de resistance, that you really wanted to have an opportunity to rebut. What did he say, the core thing that you said, if I had an expert, they may have been able to say, that's not true. Tell me that, what's the core thing?
Well, that's exactly right.
No,
Judge.
what is
By him
it?
being characterized as an expert, I'm not allowed to say that is not true.
But what is it? What is the thing that he said, though, that's not true that you should be able to refute or keep him from saying? Let's
Well-
like both ways.
Well, he's tested. He's participated in the investigation.
All right.
If you honor, please. Judge Gregg, he participated in the investigation, so he has an intimate knowledge of this case. But by characterizing him as an expert, he's now positioned in this unassailable position of giving credence to the whole investigation and all of their witnesses, because he paints it over with this big, broad brush, and because he's now, quote, an expert.
I see. So he gilded the lily for them, basically. Right, I see what you're saying.
And we have no opportunity, it's a surprise, we have no opportunity to rebut that.
it's not unusual for the government to use those types of law enforcement experts in drug cases, is it?
It's not unusual, but I contend to the court that it is rare. And we contend that a bright line should be drawn here because it invites in every conspiracy case for them to take a corporal, not a sergeant, not a captain, not a major, but a corporal out of the police department or whatever agent. We're not talking about the special agent. We're not talking about a DEA agent. We're talking about a corporal from the Greensboro City Police, could be a corporal from the Charleston Police, could be a corporal from the Mount Pleasant Police, and put him into the case as an expert 3 days after the trial has started. And if that is the case, then why not wait until the last day of trial and present your expert? Once the trial started, the lines have been drawn, you are set. Battle has been formed. The battle is joined.
Did they say they just found out about Mr. Corporal Marsh, or that they didn't know about him beforehand, or hadn't thought of using an expert or anything like that? What was their excuse for being late?
Well, Judge, I should have argued they're late, and maybe that would have kept them out. But as you can see, we went through a hearing. We said it was surprise. We said that, and the judge says we're going to go forward. And therefore, because the judge says he's going to go forward, and the standard is an abuse of discretion, I have no choice but to say, yes, the judge abused his discretion by letting Corporal Marsh testify as an expert. And I thought that he let him testify, but as an expert. Did you
argue they didn't need an expert on the relationship between guns and drugs?
Well, Judge, that was the context of my motion to limit it to identify why they needed him as an expert, but they did not address that. Because he had no publications, he had conducted no tests as to the link between drugs and firearms. So he was just...
He based it on his training and experience.
Training that he had attended other seminars by people teaching. Now, if they'd have brought the people that were teaching the seminars he had been teaching, then maybe my position would have been weakened. But if you're going to bring the student and call him the expert, what about the teacher that taught the student? They could have brought him. We're just saying we were surprised because I would have had some questions for the teacher because he'd have had some materials. He'd have had a vitae. He'd have had publications. I could have researched those and criticized those and found some counter.
Did you cross-examine Corporal Marsh?
Yes, I did cross-examine. Yes. But, again, the best, outside of cross-examination, the best test for an expert is another expert opinion. And we were deprived of that.
Did you ask for a delay to try to get another expert?
Well, we had already had 2 continuances.
Well, I mean,
in
the
this
delay.
trial, we didn't have the trial had been joined.
So you didn't?
We did not ask. We're 3 days into trial. I had, and the other 3 lawyers had invested much time and preparation to prepare for that trial, set aside other conflicts to be at that place at that particular time to go forward. There were numerous hours where we had spent in preparation together and with our clients. We were contending that that particular witness could have testified, but not as an expert.
Well, he really hadn't been much an investigator in the context of this case. He just got up there and said what he thought about the case.
My point exactly, Judge. He hadn't been that much of an investigator in this case, except that he came in as an expert and gilded the lily.
Why don't you let us see? Why don't you let the government make some arguments here? Let's see what they got to say about all this.
Again, I will join with my co-counsel, Mr. Fisher. Anytime you would like to invite my humble self to this fine city, I'll be happy to go, or anywhere else the court said. Thank you.
Thank you, Mr. Johnson. Ms. Boggs?
Thank you, Your Honors, and may it please the Court. My name is Lisa Boggs. I'm Assistant United States Attorney in the Middle District of North Carolina. Seated with me at counsel table is Stephen Inman. He was my co-counsel at trial and also assisted in the preparation of the brief. If Your Honors, please, I would like to address the issues of Alene and Davis, if the Court has questions with regard to those 2 cases, as well as sufficiency of the evidence and drug amounts. And Mr. Inman would like to address the Court with regard to any questions the court may have as to the leadership role of Mr. Jeffries, as well as the questions regarding the use of an expert witness. I'd like to first start, Your Honor.
Well, we got some questions about that expert witness, I think, but you're going to talk about something else first.
That was our intention, Judge. I'm certainly happy to try to answer any questions about the expert.
That's the way y'all want to do it.
With regard to the sufficiency, Judge, in this instance, there were several co-conspirators. Now, the term informant has been used and was used in the brief. We didn't have the testimony of informants. We had a cooperating co-defendant who was subject to cross-examination as he testified in open court. And therefore, the jury had the ability to find...
So there's a difference between an informant and a cooperating co-defendant?
Well, in this instance, often an informant in some of the case law that was cited dealt with search warrants and whether or not there could be a sufficient finding of the reliability of that informant to satisfy the proof necessary to obtain a search warrant. That's not what we had here. We had a cooperating co-defendant. That person took the stand and testified for hours.
You're talking about Williams?
Mr. Williams. But Mr. Williams, I would note, was not our only witness. There were other cooperators, Ms. Greer, Ms. Adams, Mr. Duff, and
You all gave Williams immunity?
Mr. Williams did have an immunity agreement. Yes, sir. He was
That all
convicted.
came out before the jury?
Yes, sir. He was convicted of an earlier offense, and then he agreed to cooperate. He was given immunity as to any other involvement he had, and then he testified in discovery. The immunity agreement was given out. It was subject to cross-examination.
Did he get any time in prison?
He did. In fact, he's still in prison, Your Honor. He was convicted for an offense that's occurring on the 10th of February of 2009, and an offense late in 2008, 2 searches at his home. After that time, on May 10th of 2010, he agreed to cooperate and speak with agents. Among the things he told them was he set out the story of the conspiracy. There had been numerous searches throughout the city of Greensboro of crack houses. But after Mr. Williams was arrested and talked to officers, then it all became clear as to who was working with whom and how that organization was run. At that point, he also gave information about Mr. Jeffries and a residence at 605 Waugh Street. 4 days later, Detective Alton and other members of the Greensboro Police Department went to conduct surveillance. And within 30 minutes, Mr. Jeffries was seen arriving at that location. Detective Alton had indicated he had seen and was familiar with 610 Waugh Street. And Ms. Mumford and others even mentioned that address. But Detective Alton said he had not been familiar with 605 Waugh Street other than the fact it was an abandoned house. So he conducts surveillance and sees exactly what Mr. Williams said he would see Mr. Jeffries do, about how he went out back, he had a key even though it was an abandoned residence. He also, when he did go into the residence, found crack cocaine, packaging materials, and firearms, 3 firearms, one of which was a 10 millimeter that had Mr. Jeffries' fingerprint. Before Detective Alton ever went into that house, there had been information given from Mr. Williams that Jeffries carried a 10 millimeter silver firearm. That's what was found. There was also what's known as a street sweeper, which is a shotgun, but it has a round drum. And Mr. Williams had said it looked like a Tommy gun. That's exactly what that's exactly what officers found when they searched the residence. And for sentencing purposes, those factors are very corroborative of what Mr. Williams said. But also once Mr. Williams gave a statement, then the officers went back and started talking to other members of the conspiracy. They talked to Helen Greer. She corroborated the 8-kilo trip to Atlanta and a prior trip to Atlanta.
So there was all this corroboration of the sort that Ms. Barrett was asking for.
We would contend there was corroboration. And we would also contend, as we did in our brief, if you even took Mr. Williams out, there was still testimony from other cooperators in this conspiracy which would support a finding of guilt as to that conspiracy. I'd like to move on unless the court has other questions with regard to the sufficiency of the evidence for conspiracy. I will note with regard to Mr. Poole, the case law is clear that even if you're a minor participant, and he did receive a downward adjustment for a role, he wasn't the decision maker, but he was, as the court said, an integral part of this conspiracy and played many roles within the conspiracy. With regard to drug amounts, Judge Schroeder used his judicial discretion in finding drug amounts. At the time of the sentencing, a lien had not yet been decided, but the court's decision in the United States versus Young had been. And this case followed Young, and we would contend Young actually is exactly what Alene asks the judge to do. The jury made findings with regard to the amount of drugs, and there were differing drugs. In fact, in Young, it was the same level that Mr. Jeffries was. The court, or the jury in Young found he was responsible for 500 grams to 5 kilos, but the judge at that point felt he was bound by the jury determination, and this court reversed that. But the judge had made a finding, even in the initial sentencing, that had he been able to take into account other drug amounts, he would have found in excess of the 5 kilograms that the jury had limited. So we would contend Judge Schroeder followed Young. He looked at the testimony, and there were two ways to determine drug amounts. He looked both at the number of sales from crack houses based on testimony of witnesses, and then came up with a crack amount. On the flip side, he looked at the number of trips and converted the cocaine hydrochloride into crack cocaine, because it was clear from the conspiracy they sold crack. They possessed the cocaine with the intent to manufacture and then distribute crack.
Now, but Mr. McClellan argued a lien, and what is your response to that?
A lien clearly says that that is not taking away judicial fact-finding. The facts or the elements, and Judge Schroeder actually instructed that it was an element of the offense that they were to find the drug amount parameters. So on the jury verdict, they could find less than 28 grams, they could find 500 grams to 5 kilos, or they could find more than 5 kilos, and similarly with the crack. So the judge had the jury find those parameters. And as the Young case said, once the jury makes a finding, then it is up to the court to sentence within those parameters. But just as in Young, the court could have gone above that amount. The differences in sentencing and trial is the judge can take into account relevant conduct and other factors which a jury would not at this point be finding. We would contend if you take a lien to the ends that the defense counsel would request, that the jury has to make every finding, then we're going to have juries making findings as to the number of victims in a fraud case, the amount of the fraud. What about cross-references?
Yeah, you do if it takes that to get the mandatory minimum. I think your argument is that if they found enough to meet the mandatory minimum sentence.
Yes, Judge Greger, we contend with regard to the mandatory minimums, they did make that finding.
Right.
But if you go further, then what's our jury going to be doing? You know, they would be able to hear evidence that at this point would not, such as a cross-reference on a felon in possession case. If someone had murdered someone, but we charged him with a felon in possession and started our case with the vehicle stop where the gun was found, well, now we're going to have to put on evidence of a murder so that the jury could find the cross-reference. And we contend that is not what a lien says, and the judicial fact-finding is still alive and well, as it should be. And a lien has made no difference. And Judge Schroeder, without benefit of a lien, actually followed a lien. With regard to the Davis case, that hasn't really been raised. We would contend that it does not affect Mr. Haith's sentencing. At most, it would have changed his criminal history category from a category 6 to a category 5. However, he was at a base offense level of 43, and even a 43-1 was a life sentence. 3 out of the 4 defendants before this court, based on their advisory guideline range, were facing life sentences. Judge Schroeder found facts, and Benn, for instance, ended up with a base offense level of 48. Mr. Jeffries was, I believe, 45. But the court found that that life sentence should be saved for the worst of the worst, and he varied downward on each of their cases. And we would contend that the judge's sentencing was reasonable. There was no error in this case, and unless the court has other questions, I will defer to.
What about Van and the camps?
With Van, in this instance, Mr. Haith was charged with the indecent liberties, but unlike the situation of Van, he was charged solely with the A2, the upon the body of. So Van would really, since Van had indicated that was a crime of violence, we did not have those disjunctive charging. It was only charged as the A2.
What about the camps?
Again, we would contend that because it was only charged in that one way, and based on the indictment, which would have been before the court. That particular issue was not raised at sentencing, so Judge Schroeder did not specifically make those findings. We raised that just to notify the court that we were aware that indecent liberties may have some issues, but in this case.
The decamps was decided after the trial, and
Judge, I'm sorry, I don't recall the date, but I believe that was correct.
it was decided last summer.
But if the court has any other questions, otherwise I'll defer to Mr. Inman. Thank you.
Thank you. Mr. Inman? Now, what is the jurors going to talk about?
Your Honor, if the court please, Stephen Inman for the United States. In the time remaining, I'd like to address two matters. One, the district court's findings of fact with respect to the leadership role assigned to Mr. Jeffries, and also the district court's ruling whether it abused his discretion with respect to the expert testimony of Mr. Marsh.
Why don't you do it in reverse order?
Your Honor, with respect to Mr. Marsh, and we addressed this in our brief at pages 57 and 58, trial did begin on February 13th with voir dire. We noticed the testimony of Mr. Marsh with respect to the connection between guns and drug packaging and drug prices. The main thrust of Mr. Marsh's testimony, however,
When did you do that? When?
We did that on February the 16th. And, Your Honor, Judge King had asked a question about why we did that. And
That was after the trial started.
that was after the trial.
How long after the trial started?
It was 2 days after the trial started.
And before the trial started, counsel had made a motion for expert information.
Yes, Your Honor. And we
Right.
certainly provided, say, the SBI experts who testified about the drug
Right.
analysis.
But you didn't with regard to Mr. Marsh until after the trial had started.
That's correct, Your Honor, because.
And I think you were getting ready to answer the question as to why it was late.
And in the Middle District of North Carolina, it typically comes in as a lay opinion of the officer. And so there was some discussion between Ms. Boggs and I about whether it even needed to be provided as an expert opinion. And so we decided to err on the side of caution and file the notice with respect to Mr. Marsh. We provided a CV for Mr. Marsh detailing his experience.
Why didn't you do it before the trial started? That's the question.
Because it just hadn't arisen, Your Honor, that this would be in connection, that he might be possible expert, if you will, that it wasn't going to be just similar lay testimony that ordinarily comes in these drug
Did you have an expert
cases.
report?
We did not, Your Honor. We indicated what he was going to be testifying
What
to.
is his expertise? That's what I'd like to figure out. What, I mean, expert in what? Guns and drugs?
He was talking about the connection between guns and drugs, Your Honor. And so one of, or
We
two of the
could go out and
counts.
pick out about anybody on the street, and they could tell you that guns and drugs run together.
Well, and that's what.
So why do you need an expert?
Well, that's certainly one way that this could be resolved, and that's the way this court resolved this in Pomeranke, which is to say that even if there was expert evidence that shouldn't have been admitted, it was harmless error because it's sort of common sense that guns and drugs go together. But we had a burden, and this is what the court talked about in Epps and in Pomeranke, we had a burden with respect to the 924C counts to prove that the guns that Mr. Haith possessed and
But
the
you
guns.
get up there and you call him an expert, and that just puts a ribbon on it, on top of the evidence about these fellas.
Well, Your Honor, what this court has said with respect to law enforcement experts testifying about drug trafficking and guns is that the common juror doesn't know about the connection between guns and drugs, doesn't know about drug distribution practices. And so, and Mr. Marsh testified, Your Honor, it was on 2 to 3 pages in the record about why drug dealers might have guns. He didn't talk about these specific drug dealers, why they had guns. He didn't offer anything about their state of mind. He simply said they might have guns to protect their product, to protect their money.
People in the drug business carry guns. He said that. And he talked about the types of guns.
Yes, Your Honor.
Went through a long list of them.
Yes, Your Honor.
Some of them sound terrible.
Well, it certainly was relevant to those 924C counts. And with respect to the timing, again, this goes back, as Your Honor mentioned, to an abuse of discretion issue. The judge.
What about the judge said that this is normally the way they do it, or something like that. I thought that was in the context of being late. Why are you normally late in giving notice?
I didn't think it was in the context of the way of being late. I thought it was in the context, again, of this is ordinarily late testimony and not what we would ordinarily provide and as expert testimony.
Under the rules, what kind of notice are you supposed to give for using an expert in a criminal trial?
Under the rules, if the defendant requests it, we are to provide the CV and a
notice of the opinions that the expert's going to provide and the basis for those opinions.
You didn't do that.
We did it, Your Honor. We just did it on February the 16th.
You did it late. You gave him a CV and a summary of what he was going to say?
We told him what he was going to say, Your Honor.
Did you write it down and give him what did you call that second piece of paper beside the CV? A summary of what he was going to say?
We
the
indicated
opinions?
what he was going to testify about.
You gave him that
Yes, Your Honor.
in writing?
Yes, Your Honor. I believe it's in the record. I have to look at the docket to cite it to the court. But that's what we
And you
provided.
gave it after the trial started?
Yes, Your Honor. And Corporal Marsh didn't testify until
And when did
February
they
23rd.
request it?
I'm sorry, Your Honor?
When did they request it?
They requested on February the 7th, so a week before
5 days
trial.
before trial,
Yes,
or
Your
a week
Honor.
before trial, and you gave it to them after the trial started?
Yes, Your Honor. And Corporal Marsh didn't testify.
What was your
until-
explanation for being unable to do it before the trial started?
Again, Your Honor, that it wasn't the kind of information that we typically consider an expert opinion. And so,
But we want to make that an expert opinion in this case.
and to make sure that we were going to have Mr. Marsh be able to testify, we wanted to err on the side of caution. And so he didn't testify until
Well,
February
erring on the side
23rd.
of caution would mean that you'd give it to him even without a request, but you'd give it to him timely, early on. I mean, they might come in, an expert, and say, Mr. Corporal Marsh doesn't have the right experience. He doesn't have the expertise.
Well, one thing, Your Honor, they didn't take
They didn't have an opportunity to do that.
They didn't take Corporal Marsh up on voir dire and question his expertise. And they did
Well,
not
that's
ask.
one way they could have done it before deer, but they could also brought in another expert, a retired police officer, and say, yeah, I know Marsh, he doesn't have much experience in this kind of stuff.
Well, Your Honor, he
They
didn't
could
testify.
challenge him. I mean, they could say, you don't need expertise in going guns and drugs.
Well, that's certainly one way they could have handled it. And when
But they didn't have a chance.
Well,
They
Your
were
Honor,
late.
they had a week between the time he was noticed and when he actually testified. And what Judge Schroeder said was, this is the kind of testimony that is not unusual in these types of cases. Nobody's surprised here. There's no prejudice to these parties. They've had a chance to prepare for it. And I will tell the court, the defendants never asked for a continuance. They never asked for an opportunity to get their own expert. They never asked for a mistrial in this regard. And the reason is, Your Honor, is because it wasn't surprising. It's not unusual in these kinds of cases to have police officers testify about the connection between guns and drugs. In fact, it's so not unusual that, as I said, in the Middle District, we don't typically file the notice of expert opinion about it. We ordinarily bring it in as lay opinion testimony. And it usually comes in without objection on that respect. And so, for all those reasons, the district did not abuse its discretion with respect to Mr. Marsh, and the defendant certainly can't point to any prejudice by the admission of his testimony. And as the court pointed out, it's so common sense that if the jury were to disregard it altogether, they would be left with a common sense decision about the connection between guns and drugs.
Do you have an open file policy?
We do have an open file policy, Your Honor.
Wasn't followed here, though.
Well, there was nothing in the file with respect to Corporal Marsh and this proposed expert opinion, Your Honor.
He was on your list to call.
He was on our list of he's on our list of witnesses.
Was he listed for them?
He was listed,
So
Your
they
Honor.
knew he was going to testify.
Well, we had thought that he might also testify as a fact witness, and to avoid any kind of issue with.
So that was disclosed. He was disclosed as a fact witness, correct?
He was listed on the list of all our experts, yes, Your
That's
Honor.
what I'm
We
saying.
listed our fact witness and our expert witnesses. Mr. Marsh was on that list. He actually ran a canine around some money at one point in the case, and we decided not to have him testify about that fact.
See, here, that's the question I have. He's an investigating officer in the case, and you're giving him something that we don't allow lay fact witnesses to do. He can have an opinion about something he has not seen, because he talked about cocaine production and distribution, United States. He talked about how crack houses are operated generally, how he gets to basically say, well, they normally do this to protect themselves. Well, see, he, as a fact witness, he couldn't say one of these people, they did it to protect themselves. He said, objection, sustained. He never heard them say that, but as an opinion, he could say that. Don't you think it's tough enough to defend any criminal case in a federal court? The conviction rate is so high, let alone to have an expert to be able to give opinions who's nothing but an investigating officer and say, oh, yeah, they always protect themselves. They always do it this way. And this is how they even think. That's more than just as you just says nothing, rather flippantly. I don't mean that to be derisive, but it is rather flippant to say, oh, we do this all the time. But the Middle District, your office doesn't control jurisprudence or the law or the Constitution's protection. That's a very serious matter when you're turning somebody who's nothing but a fact witness, which you almost admit to today. I can see this to be a concession of the government when you say, oh, yeah, this person, he's late. We only did it here because we wanted to be err on the side. I don't know what you call the side of caution is. But to me, you're conceding he's not an expert. And you did this, and you burlesqued this before the jury. Counsel said, the whole atmosphere. That's not just something you just whisk at. And I want to know your policy in terms of your office, U.S. Attorney's Office in the Middle District. Is this the kind of thing you think is just nothing, no big deal?
Well, Your Honor, certainly every case is a big deal.
Yeah.
Every case, certainly this drug conspiracy case was a big deal. And again, we don't ordinarily file the notices with respect to these witnesses. And so to try to follow the rules with respect to experts, we wanted to make sure that we were following them, and so we filed this notice. Now, it was late.
That's not following. You miss it. It's not following the rules when you take somebody who's a fact witness and say, we're going to make them an opinion. That's not following the rules. The rule is you shouldn't put anybody before to the court that's not an expert at all. You have a responsibility not to do so.
Well, Your Honor, he did not testify as a fact witness. He testified with respect to his opinions.
I know that. I thought to be missing with ships in the night. You can't propose someone who you know is a fact witness as an expert. That's what you did. You just admitted that normally is a fact witness, and we put him on as an expert. You conceded that already.
Well, there are some fact witnesses who offer lay opinion testimony, and this court has said that's okay, and he may have well been somebody who could have testified as a fact witness to offer lay opinion testimony. As somebody who has the experience that he does.
What do other courts say about this kind of testimony, whether it's lay opinion or expertise? I mean, he's not a scientist or anything like that, or an engineer or a doctor, or that kind of stuff, I don't think. I mean, but you say you normally use it as a lay testimony. Well, why didn't you, or a lay opinion, why didn't you do it this way? If you're, particularly when you were late, or why did you not use it at all? You had plenty of evidence anyway. I mean, the government's got a special responsibility in these kind of cases. When you got people facing life sentences, and you got arguably you thought you may well have overwhelming evidence to incriminate them, and then you end up with something like this in the middle of it.
Well, and Your Honor, I think if it had been that critical, if the defense had seen it as that critical, they would have jumped up and down and asked for more time, asked for a mistrial, asked for time to get their own expert, and they didn't do that.
Blame it on the
Judge
defense
Schroeder
lawyers.
said.
There you go. That's good. That's another good tactic.
Well, as Judge Schroeder said, Your Honor, no one was surprised by this kind of evidence, and they had a week to prepare between the time of notice and the time in which Mr. Marsh testified.
They
This
were
was
trying
not
Well,
a
I think
two-drug trial.
Mr. Johnson was at the trial, and I thought I heard him say he was surprised.
Well, he didn't indicate surprise, Your Honor, that I saw on the record. I think it was more of an objection for the record rather than an objection out of.
Then it wasn't a serious objection.
I didn't take it as a serious objection, Your Honor. I think he certainly did object to it. But again, this is the kind of testimony, as Judge Schroeder ruled, that is commonplace in these kinds of cases.
It's commonplace that the government gives the proper notice if it has an expert, and it gives the proper report if it has going to propose an expert. That's the commonplace, is to adhere to the rules, particularly when you're the government. I mean, that you got all the cards. As Judge Gregory said, you know, all the weight's on your side of the table anyway. What you got to do is be procedurally sound and come up here with a lot of baggage in your case, without a lot of baggage in your case.
Well, and certainly, Your Honor, we wish we'd filed it on the 13th and not on the 16th.
You should have filed it a month earlier. Is what
Yes,
I'm
Your
telling
Honor.
you. You should have filed it way earlier, and you should have told him, we're going to call this fella as an expert, and do whatever you think you need to do to protect your client.
Yes, Your Honor.
That's their obligation. I mean, they're court-appointed lawyers.
And I would agree, Your Honor, we should have done this earlier. But the fact is that Judge Schroeder, in his discretion, found that no one was surprised.
Judge
no one
Schroeder
was
did.
prejudiced.
He ruled in your favor, and we reviewed that for abuse of discretion. Well, we all understand that. He ruled in your favor, and he said, but he also said this is the way they normally do it, which sounds to me like that it may be an epidemic of doing it wrong. That's what worries me.
Well, I can
Maybe it
guarantee
needs to be
you,
fixed.
I guarantee, Your Honor,
Maybe you
it
need to
will
be
be
doing it
done.
right.
We will do it a month ahead of time from this point on, Your Honor.
Yeah, because that's what concerned me too, because when you said I erred on the side of caution, erring on the side of caution is not, I'm gonna have my cake and eat it too. Erring on the side of caution is, I'm late, and therefore, he is restricted to only being a fact witness. That's erring on the side of caution. It's not, I'm gonna have my cake and eat it too. I got it this way, put an expert into, and then when you get to trial, you use him as an expert. That's a serious matter, I think. Okay.
We appreciate your efforts. And
Thank you, Your Honor.
thank you for your help. And the defense lawyers have reserved some time, 1 minute apiece. We might be strict on it this time.
Actually, I'm prepared to waive my rebuttal time unless the panel has any questions for me.
Thank you very much.
Certainly.
If Your Honors, please, going to the issue that just finished talking about the expert, it is noticeable within the record and reading the discourse that went on between the attorneys and the trial court and the circumstances, how it was raised. This was a notable matter. This was not easily passed over by defense counsel. I was not trial counsel at the time, but in reading the record, you could see a noticeable change in both the demeanor and the portions of the testimony that had to deal with the police officer who was being called. I'll only note one other thing that the court's probably aware of, but I want to make sure of, that in Mr. Jeffries, you might have heard on numerous occasions where Wall Street, W-A-U-G-H, was his locale and where he was found and where his house was. There was a lot of information that was gleaned that somehow or another he was involved in some other places and did a lot of work other places. The main point that we made in terms of the quantity of drugs was that the Wall Street was his location, and that's where primarily he was found. Even the testimony from the government agents was that Wall Street was where he was generally located. So that's one reason, again, we're raising the issue as to the amount of drugs attributable directly to Mr. Jeffries. Thank you, Your Honor.
Thank you, Mr. McClellan. Mr. Fisher.
And, Your Honor, just briefly to follow up on a point that I made earlier, I mentioned a couple of the government's witnesses in this case. I specifically mentioned Tashi Mumford stated that Robert Poole was not a Bundy boy. I would just like to call the court's attention to another witness, Jacqueline Adams, I believe, who was Mr. Hayes' girlfriend, specifically stated that Poole, quote, just worked, he wasn't part of the group. And with that, Your Honor, we would absolutely agree with that government's witness. Thank you.
Thank you. Mr. Johnson.
Judge, I would briefly say that I don't try all the cases that appear in front of Judge Schroeder. I just try the case, and sometimes I plead some of my cases in front of Judge Schroeder and the other judges. But every objection I make with the purpose of objecting to the evidence that's being proposed or in danger of being admitted. I did not make any quasi-objection that I didn't have any faith or heart in as to the expert. Upon receiving the notice, I went, after talking with my client, back to my office and prepared my motion in limine, whereupon I could argue it before the court at the proper time before they called Corporal Marsh. Upon making my argument, upon reading my brief, it's in the record, or my motion in limine, the judge made a determination. I don't generally jump up and down when a judge tells me I'm overruled. I have to proceed with the trial. We contend that there should be a bright line drawn here to say that it was not an abuse of discretion in vice in cases where they make a determination 3, 4, 5 days into a 3-week trial or a 2-week trial or a month-long trial, that a witness that they generally do not call as an expert or information that they do not characterize as expert, because there may be a lawyer who may object to it, that they're now going to characterize it as an expert and err on the side of caution by then giving you notice that he's now going to be called as an expert. We would contend it opens the door in these kind of cases, conspiracy cases. We would ask the court to draw the line here, that in this particular case, when it's been asked for a week before the trial starts, in an open file policy, 3 days into the trial, that you notice him an expert, that is wrong, and the case should be reversed in a new trial. Thank you, Your Honor.
Thank you, Mr. Johnson. Before we come down, I want to particularly thank the defense attorneys for their efforts here. I know each of you is court-appointed, and it's a tough case, and we appreciate your efforts. We couldn't operate without you. We're going to come down and greet counsel and go to the next case. Is that right?